The law surrounding criminal responsibility is often defined by the tension between the commission of a prohibited act and basic intention of the perpetrator. Within the realm of serious offences such as murder and grievous hurt, the detention of a case from a conviction to an acquittal frequently hinges on the application of general exceptions, most notably the pleas of private defence and accident. Judicial between 2000 and 2025 in differentiating between a deliberate act of violence and a legitimate response to an immediate threat. This assignment offers a thorough statistical and qualitative analysis of few criminal cases during this period, looking how the legal standard of reasonableness and proportionality are applied when a defendant claims to have acted in self-preservation or when a fatality results from pure misfortune. This assignment offers a true statistical and qualitative analysis of a few criminal cases. The principle of self-preservation, which recognizes that no one can be expected to remain passive in the face of unlawful threat to their life or limb. However, the use of this right is not unrestricted, but it is strictly regulated by the necessity of the force employed and the agency of the danger. Statistical trends over the last decade suggest that while courts are increasingly sympathetic to the psychological under attack, the burden of proof remains a significant hurdle for the defense. Parallel to this is the plea of accident, which serves as a complete excuse in criminal law, provided that the act was lawful and performed with due caution. Unlike private defense, which involves a conscious choice to use force, a plea of accident asserts a total absence of mens rea or a criminal mind. This study attempts to determine the success rates of these defenses and the eventual pattern that result in judicial leniency by examining case outcome from 2000 to 2025. The ultimate goal is to evaluate the balance between the state's duty to protect human life and the individual right to liberty when intent is absent or justified. Through a detailed statistical lens, the assignment explores how forensic evidence, eyewitness testimony, and the interpretation of imminent threats have evolved in modern courtrooms. This study itself synthesizes the furnished data which gather from numerous kinds of criminal proceedings involving grievous bodily harm and homicide. Justice is the main mechanic of the institution in this analysis and provides a deeper understanding, ensuring that the law punishes the guilty while protecting those who are unarmed. Analysis of the statutory definitions and the judicial interpretations of these principles will render a clear comprehension of how the justice system weighs up the protection of society. Next, for our objective, firstly to identify the frequency of private defense, which is section 96, and accident, which is section 80, placed in selected Malaysian criminals cases to determine the prevailing legal strategy used by the accused persons. And second, to compare the success rates of these two defense to determine which is statistically more likely to result in an acquittal. Lastly, to examine the judicial reasoning and factors that influence the court decisions to accept or reject these defenses.
So, for the literature review, the offence of murder and grievous hurt have long been central to criminal law discourse. It is because they involve serious violations of the right to life and bodily integrity. Based on the news report we have reviewed, My Metro, the murder cases average 5 per week written by Muhammad Jamilul Anbiya, Muhammad Denin, and Nurul Hidayah Baharuddin on June 15, 2025. According to the Bukit Aman Criminal Investigation of Department of the Royal Malaysia Police BDRM, a total of 900 murder cases were recorded between January 2021 and at the end of 2024. 261 murder cases were reported in 2023, averaging 5 cases per week, with an average of nearly 300 murder cases recorded each year, according to the statistics from the Criminal Investigation Department of the Royal Malaysia Police BDRM. Based on this news, it shows that the number of murder cases in the country continues to rise and remains alarming. These cases do not only involve murders motivated by criminal activities, but also include offences driven by personal motive, often involving suspects known to the victims. In addition to the rising number of murder cases, the incident involving grievous hurt also shown an upward trend, further highlighting the growing concern over violent crimes in Malaysia. For example, in the news article of My Metro, the case involving a warden caning a student have been referred to the Attorney General Chambers AGC, written by Zuliati Zulkifli on December 26, 2025. This article is about the recent case of grievous hurt between a teacher and a student. In addition, the article of Forensic Examination of Grievous Hurt, written by Ahmad Masum and SMM Nafis 2021, explained grievous hurt in an easier way to understand, which grievous hurt is hurt of more a serious nature. It is sometimes difficult to draw a line between those bodily hurts which are serious and those which are light. While many murder cases are in grievous hurt are motivated by criminal or personal factors, some incidents occur in circumstances where the accused claim to have acted in self-defense. Under Malaysia Law Section 19 to 106 of the Penal Code recognise the right of private defence, allowing an individual to protect themselves from an imminent harm. However, this defence is subject to strict legal limitation, particularly the requirement of necessity and proportionality. According to the Journal Undang-Undang by M. Chiang, 1988, the author simplified the legal words in the provision and pointed out that there are several requirements to be fulfilled if the accused need to raise the defence of private defence. This journal also explains proportionality and reasonableness to raise a private defense as a defense. This cannot be seen in another news article by BH Online. The public needs to clearly inform about the limits of the right to self-defense, written by Megendra Rajagopal on January 2016. The article questions why ordinary citizens who act to protect themselves are sometimes treated as criminal. It highlights public concern over cases where individuals are charged with murder despite claiming self-defense. The article criticizes authorities for explaining the limits without adequately explaining when killing may be legally justified. And another recognized defense beside private defense is accident in the criminal law in Malaysia, written by Muhammad Sharif bin Abu Samah and Asidah binti Muhammad Ali 2017, explain about the definition and provisions of the accident. Under the penal code, accidents are placed under section 80. The provision provides that nothing is an offence where it is done by accident or misfortune and without any criminal intention or knowledge, in the doing a lawful act in a lawful manner by a lawful way in a proper care and caution. That's all. Thank you.
Hello everyone, I'm JOANNE Vanessa Andrew, and I will be presenting on the frequency and context of defences of private defence and accident raised. Under the Penal Code, private defence is governed by Section 96 to 106, while accident is provided under Section 80. Both operate as complete defences that exclude criminal liability if successfully established. However, Malaysian courts apply these defences restrictively, particularly in cases involving murder and grievous hurt. The courts consistently scrutinize the facts of each case, focusing on the proportionality of force used, the intention of the accused, and the accused conduct before, during, and after the incident. An analysis of the cases shows that private defense is raised more frequently than accident, accounting for approximately 2/3 of the cases, while accident makes up about 1/3. Private defense cases are almost evenly reported in both reported and unreported judgments, indicating its frequent reliance in criminal trials. In contrast, accident cases are predominantly found in unreported judgments, reflecting their highly fact-specific nature. These defences are most commonly raised in serious offences such as murder under Section 302 and grievous hurt under Section 325 and 326, with most cases originating from the High Court and appellate courts. In terms of the nature of these defences, private defence is usually pleaded in situations involving sudden violence or immediate threats, where the accused admits the act but seeks to justify it. Accident is more commonly raised in armed incidents involving firearms or sharp weapons, where death or injury is said to have occurred unintentionally, often during a struggle. Factually, these cases frequently involve sharp weapons and arise between individuals who know each other in emotionally charged situations, requiring courts to carefully assess whether the conduct was genuinely defensive or accidental.
Assalamualaikum, my name is EDLIN WAFIYAH. I will be presenting about success rate and court outcomes. The first analysis, which is the year, our group statistical analysis shows a clear trend in the number of recorded cases over time. The analysis began in 2002, where only one case were recorded, indicating that such cases were very rare and underreported during that period. Moving on into the mid-2000, from 2005-2009, there was a slight increase with a total of 3 cases evenly distributed between 2007 and 2009. A more noticeable rise occurred in the early 2010 between 2010 and 2014, where 9 cases were recorded. The highest number in this period were 2010 and 2014, with 3 cases each. The trend peaked in the late 2010s from 2015-2019 with a total of 17 cases, the highest across all periods studied, although there was a slight decline in the early 2020s. From 2020-2024, 16 cases were still recorded, showing that the numbers remain relatively high. Finally, in 2025 alone, 3 cases were identified. Overall, the data shows a steady increase over time, peaking in the late 2010s, followed by a moderate but sustained level in recent years.
The next one, court data analysis. This analysis examines the court levels involved in 50 cases across different stages of the Malaysian court system, highlighting how each level contributes to the efficiency of justice. Based on the bar chart, the High Court is the most frequently used court, appearing in 29 cases, which represent 58% of the total. This shows that most cases involve serious criminal matters, as the High Court typically handles serious criminal trials. It also reflects the High Court's strong authority and central role in Malaysia's judicial system. The second most used court is the Court of Appeal, involved in 18 cases or 36%. This significant number indicates an active appellate process. The Court of Appeal serves as an intermediate appellate body by reviewing High Court decisions, correcting errors in law or fact, and ensuring fairness in judicial outcomes. The final category labelled Others include 3 cases, accounting for 6%. These cases came from lower courts, including 2 from magistrates court and 1 from federal court, which usually handle simpler matters or cases at an early stage. Overall, the data shows how different court levels work together to maintain an efficient and balanced justice of system in Malaysia.
Assalamualaikum warahmatullahi wabarakatuh. My name is NORFARAH Syafiah binti HASDI, and I will be presenting about the analysis of the distribution of weapon use in the recorded case that will group into 3 main categories. The largest category is the other category, which account for 50% or 25 cases. This category includes a wide range of weapons and methods, such as bamboo sticks, bricks, firearms, blunt objects, ropes, glass fragments, vehicles, and even physical force like fists, kicks, and slaps. This shows that half of the cases involve weapons or method that do not fall under specific sharp object classification. The other largest category is sharp objects, especially knives, which makes up around 36% or 18 cases. This indicates that knives were commonly used and represent a significant portion of the cases involving edged weapons. The smallest category is sharp objects, specifically machetes, which account for 14% or 7 cases. Overall, the data shows that while a wide variety of weapons were used, sharp objects, especially knives, remain a significant concern alongside the diverse range of weapons involved in these cases. Next, I will be explaining about the line graph of the final verdicts outcomes across the recorded cases. Overall, the data shows a strong concentration in upheld conviction and alternative judicial outcomes, alongside a significant number of acquittals. The 2 most frequent outcomes are conviction upheld and other, with 15 cases each. The other category includes outcomes such as acquittals with safe custody, appeal allowed, and acquittal upheld. This suggests a high level of consistency in maintaining a judicial decision during the appeal or review cases. In addition, 8 cases resulted in conviction, representing successful prosecution at trial. On the other hand, 12 cases ended up in acquittals or discharge, where the accused were cleared of all charges. Overall, while more than 65% of the clearly categorized verdicts resulted in conviction, acquittals still form a substantial part of the final outcomes, highlighting the careful balance maintained by the judicial system between upholding conviction and protecting the rights of the accused.
Success rate by defense. Defense play a crucial role in criminal cases as it ensures the right to a fair trial and protect the constitutional right of the accused. Every accused person must be convicted or acquitted only after their right are respected, while the prosecution must prove its case beyond reasonable doubt. In Malaysia, the right to defend is protected under several legal provisions, beginning with Article 5 Clause 1 of the Federal Constitution, which guarantees that no person shall be deprived of life or liberty except in accordance with the law. Based on the 50 cases analysis, the most frequently used defense is private defense, which appear in 25 cases, accounting to 50% of total. Despite being the most commonly used defense, it also recorded the highest number of convictions upheld, indicating a relatively low success rate. Only 5 cases, or 20%, resulted in acquittal or discharge. The remaining outcomes include appeals allowed, convictions, acquittals upheld, and convictions upheld, showing a clear gap between successful and unsuccessful outcomes. This suggests that private defense may be difficult to successfully establish. The second most used defense is insanity, which was raised in 14 cases. Insanity stands out as the most successful defense, with 9 cases or 64.3%, resulting in acquittal. Additionally, 3 cases led to acquittal with an order to safe custody. Other outcomes include acquittal with detention or discharge with safe custody. Overall, insanity shows the highest success rate among all defenses examined. The final defense analysis is accident, which was used in 11 cases, making it the least used defense. None of these cases are successful. Most resulted in convictions, including 6 convictions and 3 convictions upheld. The remaining cases involve appeals allowed and final verdicts. In conclusion, while private defense is the most frequently used, insanity emerged as the most effective defense, whereas accident shows the least success rate.
Moving on, I will explain about the comparison of murder between 2 different defenses. First, looking at acquittals, private defense cases recorded about 3 acquittals, which is 23% out of 13 cases. In contrast, accident cases recorded no acquittal, showing a clear difference between the 2 defenses. Next, for conviction upheld, private defense recorded 9 cases or 69%, while accident cases recorded a higher figure of 10 cases, which is 83%. This means convictions were upheld more frequently in accident cases, with a difference of 14% compared to private defense. For appeals allowed, both defenses recorded 1 case each, accounting for 7.7% for private defense and 8.3% for accident. Lastly, dismissed appeals were recorded only in accident cases with one case, representing 8.3%, while no dismissed appeals were recorded for private defense. Overall, the graph shows that accident cases tend to result in a higher rate of upheld conviction, while private defense cases have a higher likelihood of acquittal. This pie chart shows the success rate of the insanity defense in recorded cases from 2002 to 2024. Out of 13 cases, the success rate is 100%, meaning that every case recorded that used this defense was successful. The reason for this high success rate is that the defense requires strong medical and psychiatric evidence. Under Section 84 of the Penal Code, the accused must be proven to be legally unsound at the time of the act and unable to understand the nature of their action. When the medical evidence clearly meets this requirement, courts usually accept the defense. While in murder cases, the mens rea or intent to commit the murder is required. A person who is legally and medically insane cannot form this intent. Therefore, even if the actor's rates the physical act is proven, criminality does not arise. Compared to the other defense in murder cases, such as accident or private defense, the success rate of insanity defense is much higher, highlighting how strong evidence and legal criteria contribute to its effectiveness. Last but not least, the bar graph shows the outcomes of the recorded cases for hurt and private defences with a total of 11 cases. Looking at the conviction verdicts, hurt cases recorded 9 convictions, which is around 81% of the total. In comparison, the acquittal verdicts amounted for only 2 cases or 18%. This large difference between convictions and acquittals highlight that hurt cases are much more likely to result in conviction. The data clearly shows a significant gap between the two types of verdicts, suggesting that the court tend to uphold charges in hurt cases more frequently than they grant acquittals. I'll pass the presentation to the next presenter.
Assalamualaikum, my name is MUADZ and I'll be presenting judicial reasonings and qualitative factors for our analysis. We have analysed the judicial reasoning behind our statistics, and our data reveal a significant disparity in outcomes, with defence pleas facing an overall failure rate of approximately 80%. This high failure rate suggests that the Malaysian judiciary adopts a very strict approach. The rejection of these defences is rarely due to a lack of evidence, but rather because the accused failed to satisfy specific legal hurdles, namely the mixed objective-subjective test in private defence or the strict lawful act requirement in accident. The first major obstacle we identified is proportionality under Section 99 subsection 4. The law is clear. The right of self-defense is purely protective and not punitive. And this explains why the defense failed in the case of Muhammad Zulkifli bin Ismail. The court rejected his plea because he chased the fleeing victim as soon as the danger ceased. His actions turned from defense into retaliation. And similarly, we saw failures in cases like Khairul Nordin, where the accused used a knife in the fistfight. The court ruled that using a lethal weapon against an unarmed opponent was disproportionate and inflicted more harm than necessary. Our second factor is the lawful act requirement. For the defense of accident, under Section 80, you cannot plead accident if the act you were doing was unlawful to begin with. And this explained the 100% failure rate in robbery cases. For instance, in the case of La Ode Ardi Rasila, the accused claimed his gun discharged accidentally. The Court of Appeal rejected this immediately because he was in the middle of a bank robbery, and since the initial act was illegal, the accident was legally irrelevant. We also found 0 successful accident pleas for voluntarily causing hurt, simply because the element of voluntariness is fundamentally incompatible with the concept of a misfortune or accidental or accident. And third, we analysed the role of forensic evidence. In modern criminal trials, courts place far more weight on objective pathology reports than on the accused's subjective versions of events. And this was the deciding factor in PP and Vincent A.K. Mellon. The accused insisted the victim accidentally fell onto the knife during a scuffle. However, the post-mortem evidence destroyed this narrative. It revealed a 12cm deep wound penetrating the aorta. The court held that such depth required significant deliberate force, and it was physically impossible for a passive fall to cause the injury. And we see a similar strictness in Aziz bin Lako. Here, the accused claimed he was attacked by a parang, yet police could not find this alleged weapon at the scene. The court ruled that without physical corroboration to prove that the threat actually existed, the plea of self-defense was merely a fabrication. And fourth is the aggressor rule, which serves as a strict gatekeeper. The legal principle is clear. The law of self-defense protects the defendant and not the offender. In JOANNE NPP, the defense collapsed because the accused wasn't cornered. Instead, she voluntarily left her safe workstation to walk over and confront the victim. And by initiating the movement, she legally assumed the role of the aggressor from the very start. And we saw the same outcome in the case of Jayabalan, where the accused disengaged from the fight, retrieved the weapon from his car, and then returned. The court ruled that the moment he decided to return, his intent shifted from protection and to revenge. And this kind of defense only succeeded in rare cases like PP and Chow Cheng Kiong, where the evidence was uncontroverted that the deceased owned the weapons and planned the ambush, proving that the accused was truly a passive victim with no other choice. And finally, we conducted a comparison by using the defense of insanity and comparing it with defense of private defense in murder cases. However, I want to highlight that insanity or Section 84 is not our chosen topic for this assignment. We only included it solely as a comparative benchmark to test the effectiveness of self-help defenses. And the result, we found that the contrast is actually striking. While private defense faced around 83% failure rate, the insanity cases in our comparative sample had a 100% success rate. And actually, this disparity exists because private defense actually relies on the difficult standard of reasonable man, which is a subjective test that is hard to pass in chaotic moments. In contrast, insanity operates as a medical shield As seen in the case of PP and Ahmad Tamizi, courts rarely abandon uncontroverted psychiatric evidence, and this makes the medical defense scientifically robust, whereas the plea of private defense remains fragile and vulnerable to judicial interpretation. And that's all for my part, and I'll pass the presentation to the last member to make the conclusion. Thank you.
In conclusion, the comprehensive analysis of Malaysian criminal proceedings from 2000 to 2025 reveals a judiciary that is deeply committed to balancing the individual right to self-preservation with the state overarching duty to protect human life. The data demonstrate that while private defense and accident remain the most frequently invoked strategies in serious cases involving murder and grievous hurt, they face an exceptionally high judicial threshold, resulting in overall failure rates of 80%. This approach underscores that these pleas are not mere legal witness but are subject to a strict inspection. The findings highlight that success of private defense plea almost entirely on the principle of necessity once a threat is neutralized, or if the defender becomes the persuader, as seen in cases involving chasing, as the mantle of legal protection is stripped away and replaced with criminal credibility for acts or revenge. Furthermore, the study illustrates a significant evidence shift where subjective narrative of fear are increasingly tested against objective forensic and pathology reports. The courts consistently prioritize physical evidence such as the origin of a weapon over the accused testimony to distinguish between a deliberate act of violence and a genuine accident. In the realm of Section 80, lawful act requirements serve as an insurmountable barrier for those involved in criminal conduct, such as robbery, ensuring misfortune cannot be pleaded and an excuse for harm during an unlawful enterprise. Ultimately, the trends observed for these 2.5 decades suggest that while the frequency of these pleas has increased peaking in the late 2010, the Malaysian justice system maintains a disciplined interpretation of the law. By strictly regulating the boundaries of what constitutes reasonable apprehension and lawful caution, the judiciary ensures that the law continues to shield those acting under dire necessity while decisively punishing those who use the risk of defense to cover up the bad intention.